The judge overseeing President-elect Donald Trump's Manhattan criminal trial has ordered Trump to be sentenced on January 10th. A jury convicted Trump last year on 34 counts of falsifying business records as part of a scheme to conceal a hush money payment to adult film actress Stormy Daniels ahead of the 2016 election. According to the order, Trump must appear at the sentencing, but he may do so virtually. Judge Juan Merchan previously rejected Trump's argument that the conviction should be thrown out over a Supreme Court ruling giving presidents immunity for official acts. However, the judge notably appears to rule out any jail time. He writes in a court filing, quote, "It seems proper at this juncture to make it known the court's inclination to not impose any sentence of incarceration." Trump's legal team released a statement saying, quote, "This lawless case should have never been brought, and the Constitution demands that it be immediately dismissed. President Trump must be allowed to continue the presidential transition process." CBS News political reporter and attorney Katrina Kaufman joins me now. So talk to us about what stands out from the judge's ruling.
There are a number of things that I think are interesting here. One is that the judge points out that Trump himself actually created this time period where he would be sentenced between the election and inauguration. So even though Trump is now making arguments that it violates, or has made arguments that it violates presidential immunity, that it's too much of an undue burden as he's transitioning into office, the judge pointed out explicitly that Trump, whose sentencing was originally supposed to take place back in September, asked for this adjournment until after the election, which inevitably made it so if he was elected president, and Judge Merchan says that Trump always said he was very confident that he would be, the sentencing would have to take place during this period between the election and inauguration, which is when it's now set for. Another thing I saw that I thought was interesting in one of the footnotes is that part of this argument by Trump that the judge rejects is that presidential immunity bars him from being sentenced now that he's been elected. So before he's even fully taken office, just the fact that the public has elected him should protect him here. And the judge points out that even in Trump's own motion on presidential immunity, he referred to it as specifically being for a sitting president. The judge says no fewer than 33 times.
Well, let's talk about another aspect of the sentencing, because Trump can appear in person or virtually. And Katrina, you have followed him out on the campaign trail. Do you get a sense that Trump wants to appear in person or will prefer to do this virtually?
My instinct, having followed Trump all this time, is that he would want to be there in person. Obviously, this is, a very specific time. He is transitioning into the presidency, so we will have to see what he decides here. But it has often been his inclination to be in court, even when he doesn't have to be. He often came to his New York civil fraud trial. He never had to be in that courtroom. He came to the second E. Jean Carroll trial. That was also completely his choice. And actually, an interesting thing I noticed is that this is taking place about exactly a year almost from when the closing arguments happened in his New York civil fraud trial. That was on January 11th of 2024. The sentencing is now set for January 10th. And during those closing arguments, it was very notable because Trump decided to make a closing argument. He actually didn't even really have permission from the judge to do this, but he sort of launched into that soliloquy in court. And, I don't know if he will choose to, but a criminal defendant does have the right to speak at their sentencing. So, it would be very interesting to see if Trump makes that choice. And we never heard him talk during this particular trial, whether he wants to add his voice during this period of the sentencing.
And as we're talking about timing, President-elect Trump will take office just 10 days after this sentencing. We heard from his attorneys that he should be able to focus on the transition instead of this case. Might this have any real impacts, the timing of it?
It is taking place 10 days before he is meant to take office. We are all watching this unfold. He is making nominations. He is making preparations for that transition. So, it could absolutely impact. Now he's going to be preparing for the sentencing. If he decides he does, in fact, want to say something, that will take preparation. His lawyers also have to make preparations. Two of his personal attorneys from this case, Todd Blanche and Emil Bovee, have been set to take office in the Department of Justice. So this will be a final run for them as Trump's personal attorneys in this case. So yes, it absolutely could be viewed as impacting him. But Judge Merchan has said that he does not think it is significant enough a burden, that he also feels like this just needs this finality for the jury, for Trump, because a very important thing about the sentencing is that Trump cannot appeal his conviction until after the sentencing takes place. And the judge points out that Trump has always made it clear that he wants to use every avenue possible to appeal. So to also give him that chance, this sentencing needs to happen, and it has to happen before inauguration.
Interesting. I wonder if that is actually perceived as a favor. Doubtful. Katrina Kaufman, thank you so much. CBS News legal contributor and Loyola Law School professor Jessica Levinson joins us now. So, Jessica, let's talk about the judge signaling that he won't call for any jail time, and Katrina's point that he was also saying that if you wanted to appeal and go further with appeals, we need to have this sentencing take place. Talk us through what you're seeing in the judge's decisions there.
Well, I think what we're seeing in the judge's decision is fairly predictable. And I just want to emphasize a couple of points. I don't think that any jail time was a fait accompli or was, frankly, likely to happen prior to the election. I think after the election, it was extremely unlikely. And now that we see the judge's decision here, there is a sub-zero chance of any jail time. But let's remember, these are nonviolent felonies. There is a conviction here based on a fairly novel application of the falsification of business records to this case and how it was bumped up to a felony. Now, the judge in his decision did go through reasons why he felt that incarceration might have been proper, but he says, let's all acknowledge reality. I'm not quoting directly, but reality is we're talking about somebody who's going to be in the Oval Office within the next few weeks. And so there will be no jail time. There's all of these practical and legal considerations here. And so I think that anybody who says this is shocking, they simply haven't been following the case.
So, Jessica, if there's no jail time, what are we actually looking at when we're talking about sentencing and any potential ramifications to have a felony criminal conviction for a sitting president?
So I think I'm going to answer the last part of the question, which is, what does the Constitution provide? Does the Constitution say if you're convicted of a felony, can you still be the president? And the answer is yes, you can. Now, there's really only one type of conviction that would potentially create an impediment to becoming the next president of the United States. And that relates, Lana, to something you and I talked about a lot, which is Section 3 of the 14th Amendment, and specifically the insurrection clause. This case has nothing to do with the insurrection and the alleged insurrection and any legal proceedings surrounding it. So in this case, the sentencing, frankly, I think will probably be the proverbial slap on the wrist. It looks like the judge is signaling that this is going to be an unconditional type of release, meaning that the conviction will stand, but there will be very few other sorts of concrete consequences to this conviction.
Jessica, I'm wondering, because we've talked previously about pardons. This is a state level, these are state level felonies, not federal not federal crimes. So he wouldn't have the ability to pardon himself. But as I understand it, in New York, the governor has the ability to pardon felonies, convictions. Is that something that potentially could be on the table?
It could be. I mean, and thank you for reminding all of us that the president only has the power to pardon when it comes to federal offenses, and we're talking about a state case here. Pardons are really an animal of political will, frankly, and you would need a governor who thinks that for a variety of reasons, the reasons should be in the interests of justice, that a pardon or a commutation or clemency is reasonable under these circumstances. So is it possible? It is legally possible. Governors absolutely have this power. Is it probable? I don't think that it is. Maybe in a deep red state, maybe. But the criminal justice system has functioned in this case. There was a jury verdict, and even those who might politically disagree with the fact that the case was brought tend to want to support the finality of the criminal justice system. And again, the jurors' time in this case. This was a 7-week trial.
And of course, with Governor Hochul being a Democrat, that's less likely in reality to play out. But it's always interesting to talk about the different machinations. Jessica Levinson, always appreciate talking with you. Thanks.